Good morning, Mr. Mikish. So you're charged with terroristic threat. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On August 1st, 2024, the officer was dispatched to a disturbance call, and upon arrival, the complainant and security staff stated that the defendant made threats to kill everyone, broke 2 hospital monitors, and was acting aggressive towards the medical staff. The complainant stated the medical staff became scared since the defendant stated, "I will kill you all." The complainant stated she was scared for her life since she did not know what the defendant would do next at that moment.
That doesn't sound right, because I didn't do that.
We'll give you a lawyer and we can go through this with the lawyer. So did he direct it at a person? Is he directing at the entire world? What?
The statement was only made that "I will kill you all." And it says the complainant stated the medical staff became scared, and the statement was that "I will kill you all." That's all we have from the DMs, Your Honor. And then furthermore, the complainant did state she was the only one at the hospital at the time of the officer's arrival, since the rest of the medical staff had gone through a shift change and she was the only one there. So it's not exactly clear who was there when the statement was made. He just said, "I will kill you all."
All right, so who's it directed to? Just.
I don't even know that.
The DMs does state that the defendant started to act aggressive towards the medical staff.
And
So
I think that's why she was scared, right?
it appears that it could follow on saying the defendant was, the complainant said she was scared and the medical staff was scared since he stated, "I will kill you all." So it appears that it was directed towards the medical staff.
Now, this is where the case takes a surprising turn. The judge is looking at whether the prosecution has enough evidence to establish probable cause. And the problem is, the threat itself is incredibly vague. "I will kill you all" sounds serious, but legally, the question becomes who exactly was being threatened, and does the evidence clearly connect that statement to the alleged victims? The judge ultimately finds there isn't enough probable cause to move forward. But notice the warning that follows. Even when a case gets dismissed, losing control and making threatening statements can still have serious consequences. Do you think the judge got this one right?
Mr. Mikish, patience goes a long way.
Yeah.
You know, when you get upset and when you lose control, that's why we have so many people in jail, because they lose control, they do whatever they want to do, and they don't think, if I do this, what's going to happen? If I say this, what's going to happen? Be careful, all right? All right, just hang tight for me in the back.
Hey, Judge, we've got Romero Lozano. It's a first appearance.
Okay. Mr. Lozano, come on up.
I'll help you do rear-end accident on 59. Gonna take advantage. He doesn't get right.
Any prior DWIs?
I don't believe he's got any priors of any kind. No.
Good morning, Mr. Lozano. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
Yes, Judge. On February 7th, 2025, at approximately 10:08 p.m., the officer was dispatched to a major crash on the 200 block of South US 50 freeway in Harris County, Texas. The officer met with other officers at the nearby gas station where they had moved the scene. The real witness stated she was rear-ended by the defendant and was able to put the defendant behind the wheel of the vehicle. The officer observed front-end damage to the defendant's vehicle, and the officer made contact with the defendant, the driver, and occupant of the vehicle. The officer observed slurred speech, staggering, and disorientation and confusion. The standard fields of writings were conducted, HGN 4 out of 6, walk and turn 4 out of 8, one leg stand 3 out of 4. The defendant stated he did not drink any alcohol that day, and the defendant was read the DIC and refused to provide a breath specimen. A blood search warrant was signed and executed.
Williams?
The judge sounds like there's no probable cause because US 50 is not in Harris County, Texas. That's what the road they said it happened on.
Where is it?
It said US 50. That's not in Harris County.
Yeah. And the DIMS does say 200 block of South US.
Are you serious? Do I need to look it up? I don't know.
Your Honor, the DIMS further says during the scene of the accident, which occurred on 200 block of South US 59 freeway, Harris County, Texas. But counsel is correct that before they said he responded to a major crash call for service on the 200 block of South US 50 freeway. So they put 50, but then later in the DMs, they just put 59. So they're just two addresses, so I don't know why that's there. But they did say the accident occurred on US 59.
Well, that would be a different story.
Do you have any other evidence that is pointing to that it's at 59 or is it 50?
So, Your Honor, the only thing we have is that statement from the officer, which states that the accident occurred on 200 block of US 59 in Houston, Texas, 77004.
Is that what really happened or was it on 50?
So that's what I can explain is the officer put.
I'm not working on hunches here, man.
And I understand, Your Honor. The officer initially said he responded to a crash call for service, which occurred on US 50, but then later said the accident occurred on 59. So let me see if we
Definitively
I
point
guess
where it is.
I'll check the OR and see if they clarify in the complete OR.
Yeah, he's very good.
And in the OR as well, the officer says, which occurred on 200 block of US 50, Houston, Texas, 77004.
So is 50, it's not in Harris County?
Talk about a courtroom plot twist. The entire probable cause discussion suddenly hinges on one number, 50 or 59. The report appears to switch between two different highway locations, and that matters because the court needs reliable facts before deciding whether the case can proceed. The judge makes it clear that probable cause can't be based on guesswork or assumptions. This is a powerful reminder that even in a DWI case involving an alleged crash, the prosecution still has to present clear and consistent evidence. One wrong detail in a report might sound minor, but here it became a major problem. Would you trust a case where the location keeps changing?
Sir.
Yes, Judge. On February 7th, 2025, the officers conducted an undercover vice investigation at a club known as Poppy's for operating illegally by selling alcohol without a permit and during prohibited hours. TABC confirmed that the establishment does not have a permit, and the undercover officer observed the defendant working as a bartender. The officer was able to purchase and order a vodka drink. After the officer gave him money, the defendant began to prepare the beverage.
So he's working after hours, you saying?
Yes, Judge. And he was also working at an establishment that does not have a permit.
All right, Mr. Ahete, I'm going to find that there's probable cause to go forward with the case. I ask you to do one thing, not to pick up any new cases. This is now your third of the same case. I am now revoking your bond and I'm putting you in jail. Goes with you. 5,003. It goes with you. Sorry, counsel. I can't just let it happen.
I understand.
Just over and over and over. At some point, he'll get it.
Dismissed. The first one was dismissed.
I understand, but he's on bond for one, and now he picks up another one. So we're still over and over and over. At some point, you're going to get in life.
And this is the moment where the judge's patience officially runs out. The defendant is already out on bond for a similar case, and now the court says this is the third time the same pattern has come back around. Even though the judge acknowledges that the first case was dismissed, the repeated arrests while on bond are clearly influencing the decision. The message is blunt. Bond is not a free pass to keep picking up new cases. The judge revokes the bond and sends him to jail while the new case remains active. What do you think? Fair consequence for repeated violations, or too harsh before the cases are fully resolved?
Yeah, 5,001.
Yes, sir.
Yeah.
Go ahead and sign 307.
You are Diego Camacho.
Yes, sir.
Mr. Camacho, you're charged with failure to stop and give information. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the record.